55th Circuit Court is now in session. Honorable Roy J. Meek presiding.
You may be seated. On the case of People versus Franklin George St. James II, counsel identify for the record, please.
Mr. President, speaking on behalf of the people.
Gerald White on behalf of Mr. St. James.
All right, and you are Franklin George St. James II?
Yes, sir, Your Honor.
All right. And this is the arraignment failure to appear, which is a contempt of court charge. There is a maximum penalty of 93 days in jail and or a $500 fine. You failed to appear for a sentencing. Mr. Cordero, did you ever appear for the investigation report?
No, he has not, Your Honor.
All right. How do you wish to proceed, Mr. White?
Well, it's my understanding, I've had a short conversation with Mr. St. James in the breakout room. He's requesting new counsel. We have literally irreconcilable differences as to how this matter should proceed. And I would be in agreement with him.
Is that correct, Mr. St. James? You wish to have a different attorney?
Honestly, Your Honor, I want to be honest with you. The charges that I've been charged with for all this is ridiculous. They're going off my record from my life in the past. I didn't never do anything. I didn't touch my girlfriend on this night of any of the shit I'm getting charged with. Excuse my language. I would rather just I want to see the evidence that they have, that they're saying they can put me away for it. My lawyer didn't show me any of this stuff. Ain't I allowed to see them type of things?
Mr. White, did you go over the police report with them?
I thought I did, Your Honor. We had a preliminary examination also.
Okay, and in the file is a copy of the transcript from the prelim. So, Mr. St. James, what I'm going to do is I'm going to enter not guilty pleas on the contempt of court charge on your behalf. I'm going to set it up for a pre-sentence interview, but in the meantime, I guess, Mr. White, I'd like you to meet with Mr. St. James, go over the prelim, go over all the information that you have in your file. I don't know if you can do that with in-person meeting, or you're gonna have to go through it with Zoom. And we'll set this for a status conference prior to a sentencing date. And we'll set a status conference about 30 days out.
Can I get out like for work release or anything? Because I work now. I have a really good job and I don't want to lose it. I've been being as good as I possibly can, other than this thing right here that's been hanging over my head. I'm kind of glad I'm here. I can get it taken care of. I want to be able to move on in my life.
Where are you working?
I work for Husky Metal Roofing.
Okay. And how long you been working there?
I started last year, then the COVID thing messed everything up, and I just got back, and I've been there for a little over a month now. I really love the company. I love everybody there. They're really good people. And I'm a really good hard worker, and I'm pretty sure they don't want to lose me either.
Do you have any money to put up for bond?
How much is it?
Well, right now it's at 50,000, but I'm asking you, do you have any money to put up for bond?
Yes, sir, Your Honor. I can bond out if I can get a decent bond, and I will come to court. I won't mess around because I want to get all this taken care of, so I can take care of my kids and stay home. I go to work and come home. That's all I want to do. I want to go to work, come home, and be with my family, Your Honor.
Ms. Ambrositis, anything regarding bond?
What's that, Your Honor?
Your Honor, we would object at this point for bond to be reduced. Defendant clearly didn't want to get this taken care of because he's been missing in action since at least December of 2020, according to our notes. So he's had plenty of time to take care of this. He's entered a plea. He's due to be sentenced. I think at least before any bond is considered, a reduction in any bond, he should meet with the MDOC agents and complete his PSI packet. So we have that done. And maybe meet with his attorney, because clearly he hasn't done that since December of 2020 either. And if he was so concerned about these charges and that he's being, and railroaded according to him, he hasn't reached out to his attorney to take care of it either. So,
can I speak?
Go ahead.
I've tried, Your Honor, like when this first started to happen, when this all started from the very beginning. I've tried asking my lawyer, can I see the proof of what they have? Can I, I've asked so much and went beyond of asking them. I never got anything. It was basically pushing me to take a plea. And I'm not taking a plea when I didn't do it. I can't do it. My soul inside me knows I did not do it, and I am not going for no plea I took. It's bull. I'm not doing it. I didn't do that stuff. The cops.
All right.
No, I didn't.
Okay, I've heard enough, Mr. St. James. What the court's gonna do is to keep the bond as is. We will set this for a status conference. Sometime next week. I'm not sure what my schedule is on Tuesday, the 20th, but I think we'll squeeze you in for a status conference on Tuesday, the 20th. Hopefully, Mr. White, you'll have an opportunity to meet with Mr. St. James. And we will, and at that time, we can reconsider what the bond is set at.
What do you say was that right now, Your Honor?
It's set at $50,000 cash.
So that's
Your
no
fir-
bond.
Your
thing?
first bond was set at $50,000 cash. The second, it was reduced at one point to 35,000 cash surety or 10%, which you posted, and then you failed to the peer, so that bond's been revoked. And so the court set it at $50,000 cash.
That's you can't go to a bondsman or nothing with that, right?
Oh, you can.
Okay.
He'll charge you quite a sum though.
All right. I'll see what I can do.
So we can reconsider it on next Tuesday, the 20th.
Okay, thank you, Your Honor.
All right. And we'll let you know, Mr. White, what time that is. Mr. St. James.
Thank you, Your Honor.
All right. You're all set, Mr. St. James, for today.
Okay, what do I do? Knock on the door and tell them I'm done?
Yes.
Okay.
Mr. Rowe, are you ready on Mr. Grunbaugh?
Yes, I am.
On the case of the People versus Randy Allen Grunbaugh. Counsel identify for the record, please.
Your Honor, Austin R. Rowe making a limited appearance for Mr. Grunbaugh for purposes of arraignment. Your Honor, Mr. Grunbaugh and I have discussed his charges. He waives the reading of the charges. Furthermore, we've discussed his rights. He waives the reading of the rights, and he asks for a court-appointed attorney, and he pleads not guilty.
All right. Not guilty pleas will be entered on behalf of Mr. Grunbaugh. Court will appoint Scott Moore to represent him on this matter. And we will put this on the court's next motion day, the 26th, at Mr. Moore's time of 8:45 a.m. Bond was set at $5,000 cash. Did you want to address bond at this time?
Yes, Your Honor. Mr. Grunbaugh asked the court to set his bond at $200 cash. He's lived in Clare County for 25 years. He's doing odd jobs at the moment to try to make some money for living. He has a mother, father, sisters, aunts, uncle, grandma, and cousins who live in Clare County. Your Honor, there's a concern of the COVID-19 virus in the Clare County jail. Finally, Mr. Grunbaugh is presumed innocent, so proven guilty by preponderance of the evidence. So for those reasons, he asked the court to set his bond at $200 cash.
Your Honor, just for clarification, I would like to know where Mr. Grubot is currently living. Seeing our last known address for him is not in Clare County, it's actually a Mount Pleasant address.
Where are you living, Mr. Grubau?
I don't have anywhere to live.
Okay. Court's gonna leave bond as is, and, Mr. Moore can address bond at a later date.
And Your Honor, I can put on the record, Mr. Grubauer, I forgot to say this, but Mr. Grubauer waives the right to have a contested hearing within 14 days without waiving the right to have a contested hearing.
Okay. You're all set, Mr. Grubau, for today.
Your Honor, to make sure I put the notes in the right file, are we here on the 196184 FH file?
Yes.
Yes, apparently.
Thank you.
Okay, Judge, our next case is our Karen.
Okay, have a good day.
She hasn't logged in.
She had family court stuff.
Then we're in recess.
All right. Fifth Circuit Court's now in session, the Honorable Roy J. Meek presiding.
May be seated. In the case of Kimberly Dennis, or Kimberly Hagan versus Stephanie Dennis, counsel identify for the record, please.
Michelle Resides, appearing on behalf of petitioner.
Karen Tomczyk, appearing on behalf of Ms. Dennis.
You are Stephanie Dennis,
Yes.
and you're here today in a contempt of court charge for failure to report to jail as required. There's a sentence for a violation of a personal protection order. Contempt of court can carry a maximum penalty of 93 days in jail and or a $500 fine. Bond was set at $25,000 cash, defendant's name only. Ms. Tomczyk, how do you wish to proceed today?
Your Honor, I've spoken with Ms. Dennis. She is willing to admit responsibility for the failure to appear and just ask the court to allow her an explanation.
All right. How old are you, Ms. Dennis?
37.
Would you raise your right hand and be sworn?
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God?
Yes.
One of three possible pleas you may make to this charge, Ms. Dennis. You may plead guilty if you are guilty, but don't plead guilty unless you are guilty. You may plead not guilty, or you may stand mute, in which event the court will enter a plea of not guilty for you. You understand the one of three possible pleas you may make?
Yes.
Answering to the charge of contempt of court, how do you plead?
Guilty.
And court accepts your plea, finds you guilty of contempt of court. You wish to go to sentencing today, Ms. Tomczyk?
Yes, Your Honor.
All right. Ms. Dennis, is there anything you wish to say?
Yes, I just want to say that I'm sorry. I had an anxiety attack. I panicked. I was exposed to COVID. I know it doesn't make up for anything that I did. I've been through so much, and I just am ready to see my kids, and it's just been one thing after another, and I'm just sick of doing stuff that I haven't done, so I just ask for my apologies to be accepted, I hope, and I just miss my babies. That's all I have to say.
Ms. Tomczyk, on behalf of your client?
Yes, Your Honor, and noting, like my client indicated, that the day she was supposed to appear, she did have a panic attack, made a poor decision not to appear, and then she was exposed to COVID, and she was trying to relieve herself of those conditions. She indicates to me that she is still feeling slightly sick from that, but we would ask that the court simply keep her sentence in place that she had prior to and not add any more time, Your Honor. I think Ms. Dennis understands what she's been doing, and as we indicated the last time we were in court on the violation, she has no desire to violate that personal protection order. that has been extended anymore, Your Honor. And I think if the court allows Ms. Dennis to simply serve the time that she was given on the violation, they will not see Ms. Dennis again.
Ms. Ambrositis, on behalf of the people or the petitioner?
We ask that you just impose additional, maybe fines and costs, but impose the original sentence.
In order to punish you for what you've done, attempts to rehabilitate, deter others from committing similar acts of protection of the community, be a sentence of this court on the contempt of court charge, that you be ordered to pay $100 cost. How much are you charging for attorney fees, Ms. Tomczyk?
Your Honor, in looking at this one, I will do it pro bono. I won't charge anything.
All right. And a $50 fine. And you're remanded to the custody of the sheriff's department to carry out a sentence that was previously given of 45 days, of which you should have at least one credit. Anything further from anybody?
No, thank you.
Your Honor.
All right, you're all set, Ms. Dennis.
Thank you.
Is there like a cap? We can move forward. Got a signature from you.
Ms. Tomczyk, have you had an opportunity to talk to Mr. Kaplan already?
I'm not, Your Honor.
Are you going to need a breakout room for that?
Yes, Your Honor.
All right, we're in recess.
All right. 55th Circuit Court is now in session. The Honorable Roy T. Meek presiding.
You may be seated. In the case of the people versus Stephen John Kaplan, counsel identified for the record, please.
My name is Stephen John Kaplan. All right,
Mr. Representative speaking on behalf of the people.
Karen Tomczyk appearing on behalf of Mr. Kaplan.
And this is set the probation hearing because Mr. Kaplan has not waived the 14 days. You want requested, Mr. Moore requested to be taken off the case. So we've appointed you, Ms. Tomczyk. Have you had an opportunity to discuss this case with your client?
I have, Your Honor. I actually have noticed that this is set for a status conference, not a actual probation hearing. And
Yeah.
I have discussed it with Mr. Kaplan. At this point in time, he would waive his right to have that hearing within 14 days and ask that this matter be set for a status conference in approximately 30 days.
All right, but we'll do that. So the new status conference will continue the not guilty pleas on behalf of the defendant. Anything further from either party?
No, thank you.
No, Your Honor.
All right. We're in recess.
All right. On session, the Honorable Thomas R. Evans presiding.
Good morning, you may be seated. Calling the case of Shiloh Della Schmidt versus Roger Williams Jr., file 20-900428-PP with counsel identified for the record, please.
Mr. Representative speaking on behalf of the people.
Please the court, Scott Moore for the defendant respondent.
Thank you, sir. And thank you, Ms. Ambrositis. Today's the date and time scheduled for a status conference in this matter. How did you want to proceed in that regard, Mr. Moore?
Your Honor, I've just been on the telephone with my client who's been trying for the last hour to log into Zoom. Based on what he told me, there are some technical problems beyond his control and mine. Given the nature of this case and discussions that I've had with the prosecutor, I would ask the court to adjourn the status conference for another month. I believe that this matter will resolve itself through some collateral cases that are pending. The only thing that I really hope to accomplish today was to ask the court to consider modifying PPO to allow contact between the petitioner and the respondent under DHHS supervision. Because the parties are not present, I think it might be a better course for me to draft a stipulated motion and proposed order and go back. Thank you.
Do you have any objection to that procedure, Ms. Ambrositis?
No, thank you.
Thank you, ma'am. Then we will adjourn today's status conference until 9 a.m. on Monday, May 17, 2021. And in the meantime, if the parties or the attorneys submit a proposed change, stipulated change, proposed change to the personal protection order, perhaps that will help facilitate a resolution of the case. Any bond status is continued and the case is adjourned at the date and time indicated. Thank you all for being here.
Thank you, Judge. That was May 17th
Yes,
at
ma'am.
8:45. Thank you.
I did say 9 a.m. Would you prefer 8:45, ma'am?
8:45 is my usual time of judgment. 9 o'clock is fine.
Okay, thank you. Then at 9 a.m. Thank you, Ms. Ambrositis, and thank you, Mr. Moore.
Thank you.
Can the phone number ending in 467, can you please identify for the court, please? Phone number ending in 467, can you please identify for the court?
Yes, this is Kathy Valeri.
Thank you.
Calling the case of Kathleen Valeri versus Eric Agardi, file 21-900010-PP. Would counsel identify for the record, please?
Michelle Ambrositis speaking on behalf of the petitioner.
Please the court, Scott Moore for the respondent.
And sir, Mr. Agardi, would you please stand and raise your right hand to be sworn, sir?
Yes.
Do you solemnly swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Could you tell us your name, sir?
My name is Eric Agardi.
You may be seated, Mr. Agardi.
Thank you.
Mr. Agardi, you appear here for a status conference, and you appear to show cause why you should not be held in criminal contempt of court for allegedly violating the terms of the personal protection order that the court entered against you on behalf of Kathleen A. Valeri back on or about January 13 of 2021. According to the charging document, actually the affidavit in motion for a show cause order, in pertinent part, it is alleged, quote, Eric Agardi was released from the psychiatric ward on Wednesday, February 17, 2021. He left a handwritten letter in my mailbox on Thursday, 2/28/2021. This was very frightening to me as the social worker, Lauren Schultz, at the hospital contacted me on February 15, 2021, and told me that she was concerned that when Eric was released, he was going to come to my home and cause me harm. I am concerned that Eric came to my home, which is a direct violation of the order, and left a letter, which is another violation of what was ordered. Letter is attached. Eric threatens my life in the letter, close quote. Then attached to the motion and affidavit is the purported letter. Do you understand what the allegation against you is, Mr. Regardi?
Yes, I do, Your Honor, but,
Now,
am I,
before we go further, right now, I'm just asking, do you understand the allegation against you?
yes, I do.
All right, if you are found guilty of criminal contempt of court, or if you plead guilty to criminal contempt of court, then the maximum penalty the court could impose would be 93 days in the county jail, and the minimum sentence would be discretionary with the court. Do you understand those things, Mr. Regardi?
Yes, I do, sir.
With regard to the charge of criminal contempt of court, you may make any of the following 4 pleas. First, you may plead guilty if you are guilty, but don't plead guilty unless you are guilty. Second, you may plead not guilty. Third, you may stand mute. You may stand mute and say nothing, in which event the court would enter a plea of not guilty for you. And fourth and finally, you may plead with no contest, which means that you will not contest the prosecutor's proofs, and it amounts to a plea of guilty. Do you understand the 4 possible pleas you may make to the charge of criminal contempt of court by allegedly violating the personal protection order, Mr. Regardi?
I believe I understand it, Your Honor.
Okay. Do you wish to make any further inquiry or commentary regarding the defendant's understanding of the 4 possible pleas? Mr. Moore?
Much obliged, Your Honor. Mr. Gardy, can you hear me?
I can hear you.
All right. We met last Friday in Midland. Is that right? Do you remember that?
That's correct.
Okay. And at that time, I went through what I believe the prosecutor could prove if this matter were to go to a hearing. Do you remember doing that?
That's correct.
Okay. And at that time, I advised you to consider pleading no contest to the allegation and allowing the court to schedule this for sentencing in about a month or so. Do you remember that?
That is correct.
Okay. It is still my advice that you plead no contest in order to avoid potential criminal liability in a separate matter. Also, I believe that the proofs contained in the affidavit, along with the attachment, are sufficient for the court to find a factual basis for the violation. So again, it's my advice that you plead no contest at this time. We'll have this matter referred to the Department of Corrections for a pre-sentence investigation report, and to ensure that you're staying on track with all of your treatment. You understand all of that?
I understand it, sir.
Okay. So the judge has asked you what your plea is, and my advice is that you plead no contest.
And upon advice of counsel, I plead no contest.
Thank you,
All right.
Mr. Regardi.
Thank you, Mr. Regardi. So number 1, sir, do you understand the 4 possible pleas that you may make to this charge?
Yes, sir.
Knowing the 4 possible pleas that you may make to this charge, what is your plea to the criminal contempt of court charge?
It's no contest, sir.
Thank you, sir. Do you understand, sir, that no one can make any promises for me about what your sentence will be?
I understand that.
The court also informs you that if your plea of no contest is accepted, then that means you won't have a trial of any kind, and you therefore would be giving up each and every one of the following rights. The right to have a bench trial before a court, before a judge, sitting without a jury. The right to be presumed innocent until proven guilty. The right to require that the prosecutor prove you guilty beyond a reasonable doubt. The right to have all of the witnesses against you to appear at the trial and for you and your lawyer to have the chance to question and cross-examine each of those witnesses. The right to have this court order any witnesses that you might want for your defense to be required to appear at the trial. The right to remain silent during the trial and to not have your silence used against you. But on the other hand, you also do have the right to testify at the trial. And if you choose to testify, then your testimony would be considered in the same manner as the testimony of any other witness. Now, do you understand all of these rights, Mr. Regardi?
Yes, I do.
And do you understand, sir, that by pleading no contest, that means you'll be giving up each and every one of those rights?
Yes, sir.
And I'm going to ask your lawyer, Mr. Moore, and the elected prosecuting attorney, Ms. Ambrositis, to tell us if there is a plea agreement, and if so, what the terms are. And I want you to listen to both of them very carefully. Mr. Moore, is there any plea agreement in this case? And if so, what are the terms?
No.
There is no plea agreement. Is that correct, Ms. Ambrositis?
That's correct.
Mr. Regardi, did you hear what your lawyer and the prosecuting attorney said?
Yes, sir.
Did you understand what they said?
There's no plea agreement.
Yes, sir. Do you understand that, sir?
Yes.
Now, has anyone promised you anything beyond has anyone promised you anything at all to get you to plead no contest, Mr. Regardi?
No, sir.
For example, has anyone promised you that if you pled no contest, that this court then would be lenient or light on you in any way?
No, sir.
Has anyone threatened you or threatened your family to get you to plead no contest?
No, sir.
Is it your own personal choice to plead no contest? And are you doing so freely and voluntarily?
Given the choices, I'm freely.
Mr. Regardi, the question is a yes or no answer.
Yes.
Are you doing this freely?
Yeah.
All right, thank you, sir. Do you have any questions about what the court has told you?
No, sir. It seems to be pretty straightforward.
Do you understand everything that the court has told you?
That is correct. I understand.
In light of everything that the court has told you, do you still wish to plead no contest?
Yes, sir. On advice of counsel, I'll plead no contest.
All right. And what is the desire of counsel for the court to review to determine whether there's a sufficient factual basis to accept the no contest plea, Mr. Moore?
If it pleases the court, we ask the court to rely on the sworn affidavit that was filed by the petitioner, as well as the letter that was attached to that affidavit. We believe that does provide a sufficient factual basis for the court to find that respondent was in contempt of court. We are asking for this procedure in order to avoid potential criminal liability, namely the filing of felony charges for aggravated stalking. Thank you.
Thank you, sir. Ms. Ambrositis, do you have any objection to the court considering the sworn affidavit and the letter attached thereto as the factual basis for a no contest plea?
No objection to that, Your Honor.
Do you have any objection to a no contest plea, Ms. Anguicitis?
No, Your Honor.
Very well. First, the court does find the reason given for the no contest plea being minimization of potential criminal liability in a related or in a separate but related felony case is an appropriate reason to accept a no contest plea in this case, especially since the people have no objection thereto. In addition, the court has read through the affidavit and the letter, and the court does find that those documents establish date being on or about February 18 of 2021, venue being Clare County, Michigan, identification of the defendant as well as the elements of the criminal contempt of court for allegedly violating the terms of the personal protection order in this case by having contact with the petitioner, Kathleen Galari. And the court also takes judicial notice that according to a proof of service in the file, back on or about January 14 of 2021, Deputy Kelly Bailey of the Clare County Sheriff Department served a copy of the personal protection order personally upon the respondent, Erica Gardy. Therefore, the court does find that there is a sufficient factual basis to accept the plea of no contest, and the plea of no contest is accepted and ordered entered on the records of the court. Sentencing will occur on Monday, May 17, 2021 at 9 a.m. The bond status will be continued and the case will be adjourned to the date and time indicated. But before we adjourn, Mr. Gardy, Agent Scott Coder from the Clare County Circuit Court Probation Department and the Michigan Department of Corrections is present, and he may well have some additional instructions to give to you, sir.
I do, thank you, Your Honor. What is your phone number?
989 941 9467.
And do you have a pen or a pencil to write down a phone number to call?
I do have one in hand.
Okay, this is the clerical staff for the probation department, and her phone number is 989 539 2458, extension 5. Again, that's 989 539 2458, extension 5, and that's to set up a pre-sentence investigation interview. Thank you, Your Honor.
Thank you, sir.
Your Honor, if I might.
Sure, Mr. Moore.
I don't know if I got your name right. Is Joshua in the room? Josh?
Yes, I am. I'm seated next to Eric.
It would be helpful if the Department of Corrections has a consent to share information form sent to them. And if you could call Kelly at the number that was given to Mr. Agardi, she could facilitate that. All right?
Sure.
Much appreciated. Thank you very much.
You're welcome.
Okay. Thank you, Mr. Moore. Anything further, sir?
No, Your Honor. Thank you.
And anything further, Ms. Ambrositis?
No, thank you.
Then we'll be in recess. We'll see you back here on May 17. Mr. Agardi, bond status will be continued.
Thank you.
Thank you, sir.
You can disconnect now, Mr. Gardy. We'll